Good afternoon to everyone. I'm Marco Antonio Simonelli, Assistant Professor of Constitutional Law at the University of Barcelona, Spain, and I am here today with you to present my new book, The European Court of Human Rights and Constitutional Court, a study on the European Court of Human Rights case law. I hope the sun did not impair the view too much. So, before starting to talk about this book, before I briefly present you the contents of this book, I would like to thank all the people working at Diritti Comparati, and in particular to Professor Giuseppe Martinico and Professor Cristina Fassone for the kind invitation to video presenting my book in the Diritti Comparati channel. So, what is this book about? The book, as I hope the title tells, is an analysis of the relationship between the Strasbourg Court and the Constitutional Courts of the Council of Europe from the perspective of the Strasbourg Court. This means, essentially, that the analysis of the book is mainly based on an empirical research conducted in the Strasbourg Court case law citing constitutional courts. This empirical research produced a jurisprudential material consisting of around 3,000 judgments covering 25 different constitutional jurisdictions within the Council of Europe. The overarching idea of the investigation is to clarify the current position and role of the Strasbourg Court in the European multi-level system of fundamental right protection, using as a prisma the relationship, the interactions with the other main actors of this European scenario, that are obviously constitutional courts. Those interactions have been categorized in the book as either vertical or horizontal. Concerning the latter, the horizontal relationship, by horizontal interaction, I am referring to the argumentative tools employed by the Strasbourg Court to dialogue with constitutional court. The research focused both on cases of harmony and on cases of disagreement in order to describe the dialogical attitude of the Strasbourg Court towards them, as well as the techniques that Strasbourg Court judgments adopt to persuade constitutional courts, or actually to sanction constitutional court for certain behavioral judgments. One of the working hypotheses in this regard was the possibility that the Strasbourg Court adopts a double standard along the East-West cleavage, being the application of ECHR rights more stringent concerning constitutional courts of Central and Eastern Europe compared to constitutional courts of the consolidated democracy of Western Europe. This hypothesis, however, was only partially confirmed by the comparative analysis we carried out, which indeed shows that the content of the rights guaranteed by the Convention is the same all across Europe. There are no double standards to this regard, at least we did not identify them. Concerning instead vertical interactions, our book focuses on the application of Article 6 ACHR to constitutional proceedings. As everyone surely knows, starting from 1993 with the landmark judgment in Ruiz Mateos versus Spain, the Strasbourg Court held that Article 6, recognizing, of course, the right to a fair trial, is also applicable to proceedings before constitutional courts as long as those are capable of affecting the outcome of the applicant's rights, in the Strasbourg words. What the book shows is that in the last 30 years, that is to say, the 30 years that have passed since the judgment in Ruiz Mateos, the Strasbourg Court has carried out a task of rationalizing constitutional justice, meaning that it had the opportunity to elaborate European standards concerning virtually every aspect of a constitutional justice system. From what I just said, I think a second conclusion imposes itself naturally, and is that those constitutional courts that do grant individual access in the broadest terms via a full constitutional complaint mechanism, for instance, tend to be more subject to the scrutiny of the Strasbourg Court. To this regard, it must be added that the majority of constitutional courts of Central and Eastern Europe do grant individual access. And as a consequence, the book shows that the Strasbourg Court scrutiny over them has been particularly intense, even reaching the same voting system followed by the constitutional courts concerned. Conversely, those constitutional courts that do exclude individual access, like of course the Italian Constitutional Court, the Belgian, the Romanian, more easily escape the jurisdiction of the Strasbourg Court, and in particular the applicability of Article 6, so that it can be said that up to a certain extent that are more immune to the exigencies of the right to a fair trial flowing from Article 6. In conclusion, the book draws a picture of the relationship between the Strasbourg Court and the European Constitutional Court that is composite and multifaceted, and as much as possible it refrains from formulating statements of universal validity. Nonetheless, if we are to describe the attitude of the Strasbourg Court towards the Constitutional Court of the Council of Europe with just one sentence, we can say that the Strasbourg Court posture is characterized more by an authoritative revendication of its position as primus inter pares in the European legal order, rather than a recognition of its subsidiary role with respect to constitutional courts. Thank you so much for your attention, and I hope you will enjoy reading the book.